Good evening, attorney and classmates. We are Group 2 and we will be discussing or tackling Modules 18 and 19, the privilege against self-incrimination and the right to speedy disposition of cases. So to start, I'd like to ask NADJIA, what is the right against self-incrimination?
A person's right against self-incrimination is enshrined in Article 3, Section 17 of the 1987 Constitution, which states that no person shall be compelled to be a witness against himself.
Okay, so Attorney Perez, is that right against all compulsion?
No po. The right is not against all compulsion. It is only in testimonial compulsion po. It is against the process of extracting from the lips of the accused an admission of his guilt or his confession about the crime, ganon. What is actually prescribed is the use of physical or moral compulsion to extort communication from him, and not inclusion of his body as evidence when it may be material.
Attorney Perez, magandang gabi po. Can you state examples for better understanding?
Some examples that is not in violation of this right is taking some of the strands of hair of the accused, submitting the pregnancy test, taking bodily fluids or samples from the person to determine whether he has gonorrhea. This was stated in one of our cases. And what else? Pagkukunan siya ng fingerprints, photographs, paraffin testing, as this, all of this has no testimonial compulsion involved. And the prohibition also extends to compulsion for the production of papers, documents that may be used as evidence, but except when the state has the right to compel this. That is all.
Thank you so much, Attorney Perez. Maraming clarifications. Now let's go to the next person. Ang aking katanungan po, in what proceedings is this right against self-incrimination applicable?
Okay, so I have an answer for that. Sorry. The right to against self-incrimination is available not only in criminal prosecutions, but also in all other government proceedings, such as included dito yung civil actions and administrative or legislative investigations. It may be claimed not only by the accused, but also by any witness to whom a question calling for an incriminating answer is addressed. So the expanded application of this right in a fact-finding committee, in a fact-finding investigation by an ad hoc body was illustrated in the case of Galman versus Pamaran, wherein that this right is not, in its strict sense, applicable only to criminal case. Same is true with the wherein in an administrative proceeding with penal aspect, as discussed under Pascual versus Board of the Medical Examiners, where the court held that such right extends to other individuals for the and it should not be watered down by imposing the dishonor of disbarment and the deprivation of livelihood as price for asserting this right.
What does the immunity statute grant for?
First, immunity statutes may be generally classified as into two. First is the use immunity, and the other is transactional immunity. in use of immunity or fruit immunity, this prohibits the use of the witnesses compelled testimony and its fruits in any manner in connection with the criminal prosecution of the witness, while transactional immunity is that which may be granted by the Commission on Human Rights to any person whose testimony or whose possession of documents or other evidences is necessary or convenient to determine the truth of the investigation conducted. Or it is also under its authority, which makes the witness immune from criminal prosecution for an offense to which his compelled testimony relates. This is enshrined in the Article 13, Section 18, Paragraph 8. So, are there any other questions?
No more, but thank you, Attorney Wayas. Going forward, Attorney Garado, can you perhaps answer this? What is exclusionary rule, and can you please enlighten me about the concept and the purposes of this rule?
Thank you so much, Attorney Resonable. Yung sinasabi po natin na exclusionary rule, ito po yung pumipigil po sa gobyerno from using yung mga ebidensya obtained in violation ng ating Constitution, specifically yung ating Bill of Rights. Ang aim po nito ay protektahan ng ating citizens from unreasonable searches and seizures na kinukonduct ng state through agents like yung military, yung police, and other law enforcement agencies. Yung provision po nito ay sinasabi po sa atin na yung ebidensya daw po na nakuha or na-confiscate sa occasion ng mga ganong sitwasyon like unreasonable searches and seizures is deemed polluted. Yung saan polluted, yung stain or contaminated na dapat na hindi isama sa korte during a trial. Dahil ito daw po yung sinasabi na prutas or fruit of the poisonous tree. That's why it is inadmissible bilang ebidensya, bilang gamitin na gagamitin sa court proceedings. Yung sinasabi po natin na fruit ng poisonous tree, ito po yung mga ebidensya na later na nakukuha or discovered because of knowledge, gain like from illegal searches, arrest, or in case worse comes to worse, yung interrogation. Kaya nga po yung poisonous tree na yan at yung fruit, yung dalawa po na yan ay hindi dapat na isama sa isang criminal trial. But of course, can only be actually invoked by individuals against sa isang officer or sa isang agent or against sa state.
Sir, paano naman po pag the court violated the privilege against self-incrimination?
Actually, Attorney Chester, nangyari po yun sa korte. Ito yung tinatawag natin na outside of jurisdiction. Yung privilege po na yan ay na-violate po ng court mismo sa loob ng korte, like yung judge. Now, the court is going to be ousted ng kanyang jurisdiction as well as ang kanyang proceedings, and even judgment will be null and void. A very good example actually yung kaso ni Chavez versus CA. Ang nangyari po nito, etong si Chavez kasama si Sumilang, yung kanyang kaibigan, ay bumili po sila ng Thunderbird car sa dalawang Chinese. Pagkatapos nakita po sila they met in a particular restaurant. Pagkatapos pretending na nagbabayad tong sila Chavez mismo at Sumilang ng sakyan po na yon. Pagkatapos po yung umalis sila ng sandali pero hindi pa nila natapos yung pagbabayad. Yung Thunderbird car na yan owned by Chinese, bigla na lang nawala sa may parking lot. Tapos later on nakita yon, it was repainted and impounded. Now during the court hearing, ang sabi ng fiscal kay Chavez mismo, he was called, ikaw magiging witness sa kasong to. Ang problema, kasama siya sa kaso. So he didn't like it. He felt like he was going to be self-incriminated na magiging witness mismo para sa kanyang sarili. Maraming salamat po, Attorney Chester.
So, We're going to the next module na, which is the right to speedy disposition of cases. So,
Attorney Reasonable. With regard to the right to speedy disposition of cases, who may invoke this right and what kind of proceedings?
Thank you. And the constitutional right to speedy disposition of cases is available to all the parties, not just the accused, in all kinds of proceedings, whether criminal, civil, or administrative cases, or even judicial or quasi-judicial hearings.
Okay. What are the factors to consider whether a defendant is denied of this right?
For the factors, if these are considered if a person is denied of his constitutional right to speedy disposition of cases. First, the length of the delay. Second, the reasons for the delay. Third, the assertion or the failure to assert by the accused of this right. And fourth, the prejudice caused by the delay. And we must also take note that the delay must not be because or must not be attributable to the actions of the accused.
Thank you.
Yeah, okay.
How is this right different from the right to speedy trial?
We have discussed the right to speedy trial in the previous modules, and the right to speedy disposition of cases is different from the right to speedy trial in a way that the right to speedy trial may only be invoked in criminal prosecutions in the course of justice, whereas in the right to speedy disposition of cases, as I have mentioned, it is available to all the parties and in all kinds of proceedings, cases, or hearings.
Thank you. Next question.
Are there questions?
Attorney Reasonable, can you mention a case where this right was invoked?
Okay, so in the case of Cosculluela versus Sandigan Bayan, Cosculluela was a former governor, and together with other officials, they were charged with violation of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act. And Cosculluela argued that his right to speedy disposition of cases was violated because the criminal charges against them was resolved only after 8 years since the complaint was instituted. So the Supreme Court held that indeed their right to speedy disposition of cases was violated, and this is because of the unjustifiable reasons given by the ombudsman for the delay. And in effect, the criminal charges against them, the petitioners, were dismissed because of this violation of the constitutional right to speedy disposition of cases. Are there questions?
None. Thank you, and that is all for our group.